everybody that is online joining this seminar, and I, Blanca, as well. I'm Carlos Santiso. I'm the head of the division that is responsible for digital government, open government, and public innovation at the OECD. And we are delighted to welcome all the participants to this webinar that is taking place as part of the UNESCO conference on access to information that is taking place in Tashkent in Uzbekistan. And we are delighted from the OECD to work and collaborate with UNESCO on these important issues around the future of access to information, and in particular ensuring the complementarity of access to information on one hand and personal data protection on the other hand. So that's a delight. Before going to present our panelists, just a couple of housekeeping rules on how we're going to go about this seminar. So I will ask the panelists a couple of questions as we go to get the discussion going, and then we will also have some time for questions from the participants as well. And we encourage the participants to raise their little hand to ask for the floor and to introduce themselves and their questions, indicating who their question is directed to. There's also, I will ask the speakers to unmute themselves to speak, of course, and then to mute themselves back on when they don't, so that we optimize the use of the sound. Also, for those of us that also need Spanish interpretation, it's available by clicking on the globe at the bottom of the screen and choosing English or Spanish channels as you prefer. So the interpretation is available there as well. And then I'm really delighted to have the opportunity to moderate this panel with these three panelists that will help us also discuss some of the opportunities and challenges around access to information and data protection in particular. And we are delighted to have with us first Blanca Lilia Ibarra Cadena, who's the President Commissioner of the National Institute for Transparency, Access to Information and Data Protection of Mexico. I think welcome, welcome Lilian. And then we have Linh Tong Can from the Institute of Political and Policy Studies and Media Development in Vietnam. And we also have Lilia Velasco, who is a fellow at the School of Transnational Governance at the European University Institute in Florence. So I think this is going to be a great panel and a great discussions around the advances with the access to information, which as the OECD we believe is a cornerstone of transparency as well as a fundamental human right, and it's also part of the discussions on trust in institutions and trust in government in terms of how access to information is part of transparency that is required for citizens to trust governments and institutions. But at the same time, this discussion is taking place in a context of accelerated digital transition and digital transformation that has a big impact on how public policies are made and undertaken in particular. And even though on one hand, digitalization helps improve lives, using data, the data that government has to improve the design of policies, the delivery of services, it also has some tensions and some challenges in terms of how you protect privacy and the rights to data protection in particular. And so what we see in a lot of countries in the world is also the critical role that oversight agencies have in that space, both to ensure and enforce access to information, in particular access to government information on one hand, but also increasingly so to protect personal data. And there's an ongoing dialogue and synergies that are being sought between these two types of institutions that are responsible to enforce two types of rights. And some countries like Mexico will share with us also have reformed their institutional arrangements to merge those two functions in the same institution, as in the case of INAI. So there's also a lot of discussions and a lot of consideration about what is the best institutional fit for making those two types of rights, let's say, compatible and reinforcing one another. But there's obviously some tensions. So I'll just go with the first round of questions, starting with Blanca from Mexico, because really Mexico is an interesting case in which the concern for access to information and data protections have been merged into your institution, INAI. So Blanca, can you talk a little bit about the opportunities and challenges that you see in Mexico on balancing, on the one hand, access to information and personal data protection in the case of INAI and in the case of Mexico? Blanca?
Sí, muchas gracias. Muy buenas tardes.
Hi, thank you very much, and good afternoon, everyone. Good morning for the ones that are in other countries, and good night
friends.
for
I am
the
very
ones
happy
that follow
to
us from
see all
other
of you
countries
from
as well.
all other
Well, of course,
countries,
this
and
discussion
indeed
panel
this
invites
panel for
us
discussion
to
which
share
we
with
have.
you from
It is very
INAI
important.
and
It is my pleasure
representing
to
all the commissioners
reproduce,
that are
to
part of
introduce
the panel,
you
which
the
is
people
the
from
National
Mexico, from the
Institute.
Institute of Transparency. And
So
just
we
a
can
moment.
identify all of these links and all of the tensions that you've already before, from one hand to access to information, and on the other hand, with personal data protection. And of course, how are we going to find a way that the public organisms or public institutions can find or understand a better way for this to be progressive and in benefit of the society, instead of not exercising these rights? And to begin with, I would like to thank the organization for the OECD for this discussion that I consider it's vital in a context where access to information right is getting this importance in democratic arrangements all over the world. Also, data protections, and talking about privacy that cannot be left behind, and becomes a very important condition or requirement for individual freedom. And in this sense, I would like to, besides thanking Carlos Santizo, Chief of the Division of Open Government and Innovation of the OCDE, to greet everyone in this panel. I would like to tell you that it's a privilege to share this discussion with you who are specialists in the matter. And first of all, to tell you that and talking about the public interest information, as you already know, this is not only one of the fundamental principles of the relationship between people and their authorities. It is also a requirement for democracy to work. And this is not only a quality, we're talking about a value, and of course,
Your Excellency, Miss Ibarra, if your connection is too bad, please turn off your camera so your sound can be better. Oh, we lost her.
Yeah, I think we lost Mexico, and we lost Blanca, but she's going to come back online. We hope soon, and we will go back to the experience of Mexico. That is really interesting and revealing for those discussions. But let me turn to Lynn in Vietnam also, if you can. Following a little bit the discussion we have, can you a little bit tell us about the evolution of access to information and data protection in Vietnam in recent years, and also maybe in the sub-region as well, that has a different approach to these issues, in particular in the recent decree on data protection that Vietnam has approved. So can you tell us a little bit more about how these two rights are playing out in Vietnam and the sub-region? Lynn, to you.
Thank you very much for your kind introduction, Carlos, and I would like to send my special thanks to OECD for giving IPS a chance to present on the work that we do and to find the findings about the implementation of access to information and personal data protection in Vietnam. And I would like to share the greeting to everyone in the panel. It's a privilege, and I would like to start with the implementation of the access to information in Vietnam. So first of all, it's starting with the Constitution of Vietnam, which was revised in 2013. And in that, the Article 25 recognized the right of access to information as a fundamental right. And from that start, it started to have the increasing institutionalization of this right, meaning that under the Constitution, then for the first time, we passed the law on access to information in 2016. And together with that development, another one that we are observing is now the National Assembly of Vietnam is in the process of developing the draft law on the promoting the democracy at the grassroots level. That is a very huge advancement in the context of Vietnam. And in that draft law to promote democracy at the grassroots level, then access to information is one of the core components in addition to the other rights of the citizen, like investigating, monitoring, etc. Then that is a constitution, the law level. Sorry, can I continue speaking because someone muted me?
No, yeah, we can hear you perfectly, Lynn. Please go on.
Okay. Then to continue to elaborate increasing institutionalization of the access to information, then in Vietnam, we have the sub-law level as well. So in the sub-law level, we also have the Decree 47, which was passed in 2022, and the Decree 45 and the different decision as well. But what I want to emphasize is that the digital transformation really provide a window opportunity to accelerate the implementation of the right of access to information. How? So the government of Vietnam makes the provision of the information by the public sector as one of the national priority. So they put that as they formalize that policy in different documents. So specifically like Decision 749, which talk about the national strategy on digital transformation until 2025. This is Decision 942, specifically about the e-government development towards the digital government in 2021, and Directive 2 in 2022. And in Vietnam, we also, I want to emphasize that we are trying to fine-tune the first stage of digitization. So basically moving from the offline, the paper documents to the non-paper documents. And we are concentrating in the last 5 years, the government have been concentrating efforts on building the national databases, including the National Population Database, National Land Database, National Business Registration Database, National Financial Database, and National Insurance Database. And the most important one, of course, like according to all of your experience, is the National Population Database. And that was taken care of by the Ministry of Public Security, and they have just kind of finished it, and they have the deadline to complete it by October this year. And also another effort is by the Ministry of Information and Communications to establish the National Data Exchange Platform, which connects more than 19 ministries, sectors, locality, enterprises with 10 databases. And this platform, since 2021, has facilitated over 180 million data transactions. So that is the goal of the government in this stage, to fine-tune the national data infrastructure, the core databases, so that in the next stage they can move to interoperability and the real digitalization. But that's still like in the long run, but that is a vision until 2025 and 2030. Then here comes a very interesting mix about the institutional arrangement, as Carlos mentioned before, like how we can promote access to information. Then in Vietnam, the law of access to information is under the authority of the Ministry of Justice. Okay, so that means that the Ministry of Justice will be responsible for monitoring the implementation and pushing for the implementation of this law. And in Vietnam, we have 63 provinces. So that means that under the Ministry of Justice and at the local level, we have the Department of Justice. And they are the people who are in charge of implementation of the law of access to information. That is in the substance of the law. But the Ministry of Information and Communication play a very important role here because they passed recently the most important document is they passed the Decree 42, which replaced the Decree 43 on provision of information and public service by the government officials on the digital environment. And in this document, Decree 42, then they really specify, because they provide like the technical standards of the e-portals, the e-government portals. So it provides like a really clear instructions and the platforms for the local governments to enhance the provision of information to the citizens. And in addition to that, the Ministry of Information and Communication also contributed to develop the local digital communities, meaning that like focusing on the grassroots level, so the increasing the digital literacy like from the grassroots level with the document 793. Then another one very important is that the MIC ministry also support the people with disability by passing the circular 26, which give the standards of the e-government portals to make it more accessible to people with a disability. And of course, with the role of monitoring and evaluation, they have the Digital Transformation Index, which monitors like how the provision of information on the e-government portals. And I forgot to mention, but in the Decree 42, one of the main points, which is like the new breaking one compared to the previous version, is that they really concentrate on monitoring and evaluation. So basically, they make it mandatory that the local governments must enable the function so that the citizens, when they access to information, they can provide the feedback themselves. So it's not just the monitoring and evaluations by the government agency or from the central level, but also to enable the public feedback as well. So that is to before like coming to the personal data protection, because you're asking about on these two rights. Then in Vietnam, we lack a strong and overarching personal data protection framework. So for example, in the EU, you have the GDPR, and for example, in the region in ASEAN, we have like Singapore with PDPR. But in Vietnam, we don't have that overarching framework for personal data protection. And we can claim, because we conducted that research, to review the personal data protection of the local governments in this year. We just published that report. So we can really point out, we have evidence to say that because its lack of institution and legal framework really brings out consequences, and it's expressed on the implementation of the local governments and how they protect personal data. Because we did a review across the e-government portals of 63 provinces, and in 3 channels, the e-government portal, the e-service portal. So in each province of Vietnam, we have one e-government portal that is mainly for providing information. Then you have like Another one is the e-service portal that is like on the public service when we serve there for the people, and the smart application. But of course, not all provinces have the smart applications, only 50. But still, we do the review of the personal data PDP practice across all of these channels. And what we find is very interesting is that because we don't have these legal frameworks, so and in our current regulations on PDP, it's dated back to 2010, 2011. By that time, PDP has not yet become like such a prominent issue. Like nobody was like talking about data processor or data controller. So that was like very obvious in the regulation back at that time, which was still now available because we haven't not yet passed new regulations. Then in the previous regulations, they were saying that, so they only differentiate between government agency and private companies or the service provider as private companies, but they don't distinguish between data control and data processors. So the consequence is that in most of the documents that we review, we call them the privacy policy, but they are not full-fledged privacy policy, but they are those policy. But this policy do only in one case that they correctly identify the people committee of Hậu province that was correctly identified as a data controller. That means that they are responsible whenever there's data breach or whenever the citizen want to revise or update data, because with the correct identification of data controller, then comes a respective responsibility of the local government on that. But from this very stage, because of the missing or outdated PDP regulations, then they do not even identify correctly who is the data controller and who will be responsible or accountable to the personal data collected from the citizens through all of these e-government channels. Then with that, then because I think that the time is like also running, so I just want to say that
no, I think we can go. We can. I mean, you can continue also, and we'll go back to this important issue you raised around the local level, which is really fascinating. But please proceed.
Yes. Then in Vietnam, as I mentioned before, 63 provinces, right? But in terms of the e-government portals, which provide like the information from the local governments, then only 3 provinces have the existing privacy policy, which is like very less than 5%. And in terms of the e-service portal, which collect a lot of citizens' information, but only 4 of them already have this privacy policy. And another interesting thing is also about the lack of responsiveness to citizens' requests. So what we did is that we sent out 130 emails. The emails that we collected from the e-government portals, e-service portals, and the privacy policies that we found, and we sent 130 emails. But we received only 9 responses, which is like a small percent. And among these 9 responses, we received only 1. Because in the email, we play the role of the citizens, right, for the test. And we asked 2 questions. So first of all, is like, how can I update the information on that e-channel? And because in Vietnam recently they changed from the ID number from the 12 number to from the 9 number to the 12 number. Then the second question is like, can I know what are your policy about like personal data protection, so that we can assess them? And in only one case among 130, then cases, then we get like kind of good, adequate answer to what you ask. So, so about the linkages between the access to information and personal data protection. So from our own experience, because when we review the personal data protection practices of local governments, what we also observed is that in many cases, when the local governments have published information on their local policy, so sometimes the policy can be about, one example is like under the COVID times, and the local government needs to share the information about like who is going to receive the government support, like that social security support because of the COVID, right? Then in that list that they provided, yeah, it's supposed to be transparent, but not so transparent to the extent that they know they also publish like the email, telephone number, home address, and how much money they receive and everything. So basically, so the overall observation is that they do not yet pay so much attention to the personal data protection. They are not so much aware of that yet. And about the linkages, so about 3 points. First of all, personal data protection can be used as an excuse for refusing to provide information, access to information. Because in the law of access to information in Vietnam, so one of the categories that of the information that can only be provided on conditions is information related to personal data. So here, the personal data protection can be used as an excuse to refusing to provide access to information. The second point is that access to information without consideration to personal data protection can violate privacy rights, as I mentioned in the previous case of the COVID information. Then the third one is that the strong personal data protection framework can actually significantly contribute to enhance access to information, because then the local governments will know exactly which information can be shared, which cannot, or if they can only be shared in certain conditions and what are the conditions to be shared. Then I also would like to share one very interesting case study in Vietnam. That is the case of, for the first time in Vietnam legal history, is that one citizen bring to the court the People Committee, the head of the People Committee of Khánh Hòa province. So in that case, because that person is the head of the household, and that household was affected by the land plan, like because the local government, they provided land for one private company to develop like a resort. But this affects the livelihoods of this household. And this had this family, they wanted to sue the private company in front of the court, but they do not have enough evidence. So they requested access to information about the decision of the People Committee on deciding to approve the land ownership of this private company. A local head of the local People Committee refused to give this information on the basis of business secret, because they say that if they provide this information, it can affect it can consider like a business secret of that private company, but in fact it's not. So this is just like one illustration. In case of personal data protection, it can be the same. They may request something, and on the basis of like, oh, we want to protect the personal data, then we use. But the case like still ongoing in Vietnam. But that is to say that it's getting more and more attention. But overall, according to our survey with our partners, CSO partners, we can claim that we can say that the the demand side for the access to information is not yet so high in Vietnam. So mostly it's like active intervention from the government that they want to develop the digital government. That's why they try to accelerate this process. But in terms of the citizens, they do not yet understand what rights do they have with regards to certain information. So they have not yet many cases. If you ask about, Carlos, you also ask about how is it in the region, then I can say briefly, maybe my other colleagues in the audience, maybe they can jump in and provide more information later.
Yeah. But maybe, Lynn, we can go back to this further in terms of the regional outlook, because that's quite fascinating. Sure. Also in terms of, go back to some of your important and interesting work that you've done at the local level, because this dimension of local in Vietnam is really fascinating in terms of how these things also play out at that level, and in particular as a bottom up. And we'll come back a little bit also to get the findings of your important studies on local government data protection by local governments. But just like for getting the conversation going, maybe having, I think Blanca is, no sé si la Presidenta Blanca si está en línea o vamos a esperar que vuelva un momento, pero in the meantime, let me turn to you, Lucia, because it's also a very a pleasure also to see you again, and also the role that you have taken in Spain and in Europe around the digital rights charter has been quite inspiring for many. And Lynn was really also mentioning in a case of Vietnam how digital transformation has accelerated access to information. But there's also some challenges that they pose, no? And in terms of making those two rights, the right to information and the right to privacy and data protection, how are these things being playing out in Spain, and in particular in the discussions around the Charter of Digital Rights, and how government can really also regulate or, let's say, guide the development of those rights in the digital area, because digitalization changing a little bit the rules of the game in both sets of rights. Lucia?
Exactly. Thank you, Carlos. Very nice to see you again. And hello, everyone. As it's been said, digitalization comes with a promise of improving our lives and our rights. And this promise has been delivered somehow and sometimes. It has provided certain rights and freedoms to be expanded and better protected, and notably allowing individuals to be heard, to express themselves, or by having better access to information, to be closer, to create communities, to be connected, to be able to participate socially, and to exercise political rights. At the same time, as you were saying, it is also creating significant challenges to several fundamental rights, such as privacy, the use of personal data, and it is also affecting equality of opportunities, even fair treatment when we start to talk about automated decision making, because we are all more or less aware that there are some bias hidden in the use of artificial intelligence. There's also data invisibility of certain communities, and there's also discrimination through the wider possibilities of diffusion of hate speech, harmful content, gender violence, and all sorts of toxic algorithmic amplification. And that is probably the reason why there's now a recognition of the need to act to better protect citizens' rights from the government and non-government actors in the digital space. How could governments proceed, right? It was very interesting to listen to what Lynn was explaining. Countries are increasingly taking steps to ensure that human rights and democratic principles remain protected online. And it is, it is a decision to make if you want to go to specific rights or you want to create that overarching concept of digital rights. Some countries have developed new regulations. Some countries are working regionally on declarations. We are seeing charters to define these fundamental rights and freedoms in a digital context. And we have a variety of options. Some of these rights are new, and we need to start from the beginning and do a collective reflection and understand what implications, for example, neurotechnologies will have on our rights. And we see this with Chile being a pioneer in the neuro rights sphere. Some are not. Some need to be reinsured in this new reality, such as data protection, privacy, and the protection against digital violence. That is a reality that has been translated from the analogic world to the online world. There are several countries working around this topic. Canada has introduced, for example, the Digital Charter Implementation Act. Of course, at the European level, we have the European Council adopting a Charter of Fundamental Rights in the context of artificial intelligence. More recently, in Europe, we saw the European Declaration on Digital Rights and Principles of the Digital Decade. Spain, one of the first movers in Europe with the Spanish Charter that you mentioned, and Portugal as well with the Portuguese Charter of Human Rights in the Digital Age. There are several approaches to show a country's compromise and commitment with digital rights. But for sure, this is the first step, not the last one. We need now to walk the talk. We need to understand how to, as you mentioned, we create that institutional architecture to make sure that we can make those rights become a reality and not only, a piece of paper, as Lynn also mentioned. So I will leave it here, and I will wait for a further discussion.
Yeah, no, fascinating, and really a lot of work coming out from Spain on these issues, and sometimes there's a challenging dialogue on synergies between the different sets of rights, especially when you add that in the digital space. And Blanca is back with us. Espero, Presidenta, que nos puede escuchar. Ahora, ¿está bien?
Can you hear us now? Yes. Yes. I'm sorry. I had some trouble with the connection, but I was telling you about that. First of all, it would look like the right to access to information is it's not linked to the data protection and privacy right. Well, it constitutes a central point as well that today we must think about, we must reflect on and analyze how to conciliate both rights. And if the laws of access to information talk about a fundamental right for everyone to have access to information in hands of the government bodies, and also the laws to right to privacy and data protection give the population this power to control the compilation, the access, and the use of information that identifies them or make them identifiable. However, it is important to say that it's a little bit more complex this way that these two meet or they face each other, especially in the digital era. We say that there are two faces of the same coin, and well, they act like complements to each other that promote the rights to people and that look to promote the government's responsibility. And out of these two, we have one of the most complex relationships where the authorities must be on behalf of the transparency, but also that they agree with the human rights. So on one side, I consider that the public institutions must allow, yes, as we've already said before, the access to government files. So starting from that principle of the information, and on the other hand, they are forced to give and adopt the necessary measures that will make sure that any personal data in any official paper is kept in a good way to guarantee the right to population to protect their data. And in that sense, the openness of the public of data, it's not translated in restrictive access, but in some cases where the human rights get into conflict, that we get a responsible exercise that is careful of these right ponderation, so we get the balance between the social wellness and individual freedom. And this is where access to information and data protection. Here we have a protection dimension facing the state, and that the bodies that in the case of Mexico, we have to be clear and efficient, not only by addressing the law, but also in the assessment that will be done between the possible collisions of both rights. And in this context, if you allow me, I will give you a practical focus and capable of conciliate any collision or conflict between the right of both right, the exercise of both rights. It has to do with assessing the openness or not of the information, and starting in a particular level that if in the case we get the elements to consider that there is a public interest, this is something very important to taking into consideration the data, personal data protection, and also to guarantee and respect these principles, this progressive interdependency, indivisibility, and universality matter. So I would just say that this is important to have this interest public test as an ideal mean to determine pertinency to disseminate personal information. And according to these tests, under the supposal of requiring the information of the requesters that has this personal information and its dissemination will make any harm, well, this can be open only and only if it is determined by a public interest. And this has happened in the Mexican case. This is how we've done it in a responsible way by a responsible body of the country. When we are looking forward with this interpretation methodology, is that in those cases where the two fundamental rights get into collision, this problematic will be solved by addressing the features and the nature of the concrete case, looking forward to not to sacrifice the values or principles with a higher weight to the one that we are looking forward to please. Thank you very much, Blanca. But now let me do a follow-up with this reflection in Mexico's case, that because we are very interested, because in some cases, as you described, where there are some tensions and even some conflict between both rights. In the case of Mexico, INAI is the one that solves this. And then there are a few countries that have or in which an institution has a responsibility for both rights. And so the mandate of this to assess or to balance these two rights when they get into conflict. And in the case of Mexico, can you tell us a little bit about the government of Mexico's motivation to have these two rights under INAI, and which are the advantages, but also some of the challenges that this model offers? Yes, and in the case of Mexico, INAI has to safeguard the rights in a simultaneous way, just as you mentioned. Duality is an opportunity is already established because these rights, as we already mentioned, collision some part, and so understand and define first one, it's to limit the frontiers of the second, and the other way around. And so for this, in Mexico, we have a normative fundament in Article 149 of the General Law of Transparency and Access to Public Information, as in the federal law in Article 155, where we say that INAI that must solve these topics where we have a collision of rights through these public interest tests, which I already referred to. And I refer in a quickly way, in an initiative way, I'm not going to describe them, the principles to determine which right must stay. And we are talking about the right of need, and to give this in a strict way. This is translated in the balance between the prejudice and the benefit in favor of the public interest. And to lend this idea, well, there are some examples. I don't know if there's time to show them, or we will leave it to later, for later. Yes, we will come back to that. And now, going back to Lucia, because of the same area, I don't know how to talk. I don't know if I speak Spanish or English. No, I don't know. But
in particular in Uzbekistan there. But it's very interesting, the case of Mexico. And what are your takeaways in Spain and in Europe about, how, whether basically the institutions that are responsible to upholding those rights are fit for purpose, especially this right between access to information and data protection. And Spain has a long tradition of data protection, in particular the agency. And how do you see, this institutional challenging playing out, also in the broader discussion that you mentioned around digital rights that are even a broader set of rights? But can we learn something from this interesting, let's say, tension between two sets of rights, access to information and data protection in the digital space, for the way governments the way governments can reform their institutions to make them fit for that new age?
That's a very good question. I think that as starters, we need to be very honest in the conversation, right? And we need to recognize that even if we have been known for having an effective system of protection of data, let's say, of personal data, most of the citizens are not able to access that. And every day we suffer an abuse, a systematic abuse of our personal data everywhere, all the time. So it doesn't seem to me or to an average person that we have been very successful here. Even with the big corporations, when they are fined, they're fined with such small figures, and it's so difficult even to collect those fines that they don't have any incentive to act. They usually are underfunded as well. They lack human resources. And so there's a lot of challenges around how an institution effectively delivers what it's been created for, right? And we need to be very, as I was saying at the beginning, we need to be very honest with this when we are shaping the new the institutional architecture around digital rights. And we need to understand that it's not about one right, 2 rights, 10 rights. We need to make probably a broader agreement of what we are talking about, and understand that these rights will at some point be expanded, because it's how it goes with the digital challenge, that we have now, every now and then, new needs to cover. So we need to be very flexible, and we need to establish a common understanding of what we talk about when we mention digital rights. And I believe that this should be done at a supranational level. If each of the countries and within the countries, each of the regions start having their own institutions or their own understanding of digital rights, it's not going to be effective as it is not right now. So we will need to learn that one of the elements of making effective a right or allowing citizens to exercise rights is not only that you have an institution where you can that you can refer to, but also you need to have a judiciary system, able to come after any infractions and able enough, we're not asking not it to be collapsed as it is in most of our countries, because the judiciary system is already collapsed and we have waiting lists and people without access to justice already. Now, if you add another set of rights and another set of knowledge that this system needs to absorb, we need to be very mindful of this. So we cannot reduce this challenge to one agency, one ministry. This is a systemic approach, and we need to understand that affects every single element of the government, probably, and of the democratic system. And for that, we will need to have those who are fostering, those who are promoting, and those who are enablers of this digital transformation adaptation, and on the other hand, we will need to have those actually transforming it to their regulations and to their systems, and those will be probably different actors in the government.
No, that's an important point also that you bring onto these discussions about the role of the judiciary, really also in enforcing those rights and also providing mechanisms of redress. And so there's a lot of actors involved, but Lynn, let me go back to you also with the questions around the important point that you make also in your interventions around the importance of the local level in which these issues are also taking place, in particular for things that are important for people in dealing with local authorities that have their own mandate. And you just concluded a review of Vietnamese local governments and their adherence in the implementation of data protection and personal data protection in particular. Can you share with the audience a little bit like the 2 or 3 key sort of conclusions of that study, but also what are the policy recommendations that are coming out of your analysis in terms of how, let's say, local government actors can help enforce, but also make those both sets of rights compatible? But before giving you the mic, Lynn, if you don't mind, I'm also just opening for the audience that if people are starting to also have questions or they want to intervene, please raise your little hand, and also our friends that are on site in Tashkent, also maybe raise your hand. I can see you there, but I also wanted to open the discussion with the audience. But before, Lynn, maybe if you can come back to this question about what can be done at the local level to make those 2 sets of rights more sort of compatible and enforced. Lynn?
Thank you very much, Carlos, for your very interesting question, and also thanks to Lucia for the emphasis on the judiciary system. So back on your point about the roles of the local level, so I must claim, like from IPS involvement with our partners, CSO's partners here, that implementation of the access to information and personal data protection are mostly done at the local levels, right? Because at the local levels, they are the direct interaction with the citizen. So what is happening at the central level, like, okay, the Ministry of Justice can propose it, okay, we have to have the law on access to information. and then we have the law, but then how that law is going to be implemented, and it really has to come down to the local level. And from our research experience, and we really find that the local governments, they have challenges both in access to information and personal data protection on how to specify or concretize what the laws say. The laws say, okay, provide information, but then how do they do that? Then the local governments, different agencies, like from the people committee to the different departments and the commune, the district level, mostly when we ask, the key challenge for the government officials at the local level is that they are not confident in knowing which information can be provided or not, and they really lack the heads of this local agency. They always emphasize that they do not yet have their own internal kind of rules or regulation within that agency. So first of all, if I'm talking about the Department of Information and Communication, for example, if they pass some decisions or if they pass some directive, then how are they dealing with? What is the process of the people of the workers there, so that they know that, okay, so when the head pass or approve these decisions, then what should I do next to ensure that this information is provided publicly available on the e-government portal? So they are missing, mostly the key challenges are the capacity of government officials, and they also are lacking that internal regulations and internal rules to specify this. Then another challenge for them is also about infrastructure, but I would rather focus more on the regulations. And similarly, in personal data protection also, then actually, even without the overarching personal data protection, but we already have kind of a legal framework with certain rights of the citizen with regards to their personal data and the responsibility of the local governments to protect the personal data in the existing regulations. But even within that, incomplete in existing regulations, but the local governments, they still have not been able to implement all of these requirements. So for example, they know that in the law, it says that, okay, the local government, they have to publish they have to inform the citizens of what kinds of information do they collect. They have to inform the citizens of the measures that they implement to protect the personal data. But in what form or in what way that they can inform the citizens about this, then they do not know yet. And that's why, in the next step, and we in our review, we propose that the Ministry of Information and Communications provide the instructive degree or directive to give the sample privacy policy and the sample personal data protection regulation for or the contracts for the local governments to have a certain point to refer to when they are implementing all of this. And if you're asking about overall recommendations, and we have different sets of recommendations, but the most important thing is that we really emphasize on the importance of making the at the national level, then it's really important that in the regulation, because actually there is a tendency that the government, they focus more on data security rather than data privacy. But data privacy is about protecting the rights of the citizen towards their personal data. But when we talk about securities, and mostly the government understands it as a security on the IT system or security of the organization. So they have to differentiate clearly between the data security and data privacy. The second point at the national level is also like strengthen, of course, the personal data protection framework and the technical instructions. So, for example, encourage the local governments or government agency in general to adopt the ISO 27701, which is like the new ISO standard that already incorporated some personal data protection standards. Then they also need to work on data classification and other regulation in general. And they also, we also encourage at the central level that they recognize the privacy policy as a kind of digital contracts between government units that collect personal data and the citizens. And if the legacy of the privacy policy is recognized as digital contracts, and that can be quite a powerful reference point for the citizens when they demand their rights to be fulfilled by the local, by the government agency. And we also encourage at the national level to establish like a centralized personal data protection and the access to information complaint system, so that at the central levels they can really observe how all of this are going and collect all the complaints and be able to develop like a nationwide solution. Meanwhile, at the local level, we encourage them to be more accountable and publish information about like data breach and privacy impact evaluation. We also encourage the local governments to really focus on monitoring and evaluation of the accessibility and usability with the local community. So, for example, what we are trying to do with the Hazan province in promoting the access to information and personal data protection is that we will work with like local communities and let them use smartphone, because like almost 98% of business people have smartphone, but not everyone have access to the laptop. To have them go through all of this, like to do the usability test, so that they have a taste of what it's like to search for information from the government. If I have any question, what can I ask? Or if I want to complain about my personal data violation, then what can I do? So, like really, if the local governments, if they want to strengthen the implementation of access to information personal protection, then they can really use this method to enhance that. And of course, like appointing the contact point for access to information and personal data protection, and focusing on capacity building and building internal regulations. So that is just a brief overview. Hope that answers your.
No, thank you, Lynn. I mean, it's an important point also about the issue of ensuring anyway the security of the data in all cases, which is also part of this important equation. And also one other point that Lynn also mentioned, but and I'll go to you, Blanca, also about this point, about the importance of having independent institutions that are responsible for enforcing those rights and having mechanisms of redress. Lucia also mentioned the accessibility of citizens to these mechanisms. So, but Blanca, in the case of Mexico, what takeaways and recommendations you can draw from this experience in terms of the importance of having an independent institution that is responsible for enforcing those rights? So the case of INAI is really telling in that sense. Blanca.
Sí, mira, el beneficio más importante.
Yes, the most important benefit of having an independent or institution is that it gives the citizen this opportunity to be confident enough to know that this institution that is in charge of these two human rights, which is access and personal data protection, will act in independency principles and responsibility principles without having any intervention that can alter or affect the resolutions that can be solved or that can be addressed. And also, it is important to have an independent or institution because it adds up to the shared experience and the processes. Just as we've mentioned before, we have an interrelation between these two rights that can be in conflict. And by having a technical organism that I may insist this is very important, technical and specialized, it is also capable of solving what these rights represent. That it's not only simplified in the interior of administrative entities without the need of having these bureaucratic processes, but we can also reduce the possibility of institutional conflict. Now, in practice, let me tell you that a lot of information requests under the access to information legislations, well, these are related to personal information. And by having this dual experience, we have a better balance between these two rights. For example, by balancing this public interest test that I've mentioned before. And in this sense, from INAI, we've always tried to have a constructive dialogue with the authorities and also to boost in a proactive way the training, updating of all of these people that have this responsibility of taking care of the databases, and also to look forward to have other platforms and other actions that will allow to have an effective training and a better knowledge of the population about the exercise of these rights and the way that they should protect their personal data. And in such a way, with the experience and the internal comprehension of both problems, the decision-making process has become an continuous improvement mechanism that has boosted us to have better practices in the matter. There are a lot of challenges that we have to face, of course, and also to conciliate both rights for population. It's always has to do with an institutional commitment and stick to the rules. But we face as institutions to look forward to safeguard these rights, and just as this panel and have these panels just as the ones that we have starting from the International Day of the Universal Day of Access to Information, this will allow us to know the experiences of other countries and how they are facing this with the use of technologies. And we all know this. It's important to go on with this, and just as independent organisms, we have to have a more progressive comprehension of this data protection.
Y también un poco
yes,
resaltando.
Important, and also highlighting what Lane was saying as well, the role of the institution as INAI and also as local governments, the states, and it's important to have into scope this.
I'm just also seeing if there's any questions or people who want to intervene both online or in Tashkent, please raise your hand. We're monitoring also the chat line if people want to have a question to a panelist. So, but feel free to do so. But going back to you, Lucia, and also these discussions around whether our institutions that were a lot of them created for another age, including access to data protection, for example, or access to information in particular as well. The extent to which they are the right ones going forward. In Spain, for example, there's been the recent creation of new institutions. For example, Spain would be one of the first countries in the world to create a dedicated oversight agencies for the use of artificial intelligence that also includes the use of artificial intelligence in and by the public sector, which is also an area that also combines these concerns around access to information and data protection, because it relies on data owned by government or held by government. What's the thinking in Spain and in Europe about this type of agencies, and making sure also they have the right dialogue with others that are also responsible for the rights? For example, the Agencia Española de Protección de Datos.
In Spain, what we are looking at right now is like 3 different agencies. One of them is the data protection one. That's the more traditional one that was created when this was included in the legal framework, and also by request of the European Union. Since we have European law, we need to have national institutions coordinated at European level. That is sort of how European architecture is looking like right now. What it was announced before the Artificial Intelligence Agency was the public service, digital public administration agency. I don't know the translation, sorry, but it would be like the digital agency in charge of all the digitalization of the public administration. And this is also underway of becoming an agency itself. Is now a department within the government, and is meant to be an independent agency, similar to the ones that already are in place in the US maybe, or in the UK. And thirdly, we are looking at the Artificial Intelligence Agency that hasn't been created, although it has been announced, and that is still to be designed, to also respond to the European regulation in this scheme that I was explaining before, where we have European regulation, European body coordinator of the implementation of this regulation, and then the national counterparts. And we will see how this comes up. One of the innovative things that we proposed from Spain, it was to test this regulation, to propose a 2-year try test through this agency to make sure we were able to feedback on the implementation of this AI regulation that, as you may probably know, will be the first of its kind globally. So that's a little bit the idea. Of course, there's challenges. I am very, very concerned about the talent challenge, because, as you said, the administration and the civil servant access is designed in another time completely. And if you want to have people very updated in technology and in contact with the market and with what's going on out there, we need to be able to be more flexible when hiring people to work with the public administration. And until now, it has been very restrictive, and it has been not at all competitive salary-wise, very difficult to enter, and then once you enter, you don't have a lot of options to promote, and therefore you get stuck in your position and nobody enters after you. So the talent challenge is as important as the rest of them. We usually talk about money and funding and the need of funding when we design these organizations and these institutions. But I believe that in this particular topic, such as technology, we need to think out of the box.
No, thank you, and that's quite interesting also to see the case of Spain on how we can also make sure that the different agencies that are enforcing different types of rights also coordinate somehow between themselves, which is a different case than Mexico. I think we're going to closing. Let me see. we're going to now I'm just like looking at the chat as well. There's some discussions going on, but I think we need to close this this discussion, and maybe I'll give you the floor to each of the panelists, maybe to share with the audience, in particular those who are listening from Tashkent in Uzbekistan, what is your main recommendation or your main policy takeaway from your experience in Vietnam or in Spain or in Mexico around the synergies, or let's say the tensions on how to resolve those tensions between access to information and data protection. Just going through the panelists, and then we will close. Starting with Lynn.
Once again, thank you very much, Carlos, and thanks to OECD for this great privilege to be here today and listen to Blanca and Mexico experience, and also listen to Alicia and Spanish and the European experience. And I have indeed learned a lot. In terms of the key takeaway, I think the first one I would like to emphasize is that the right of access to information and the right to personal data protection, these are not the zero-sum game. It's not like you have one without the other, but it's actually the personal data protection will only help to strengthen and promote the right of access to information, because it brings the clarity about like what or what not can be shared. The second point is that monitoring and evaluation is extremely important to ensure the effective implementation, because the laws or regulation are not supposed to stay on paper, but they are supposed to be implemented. And when we talk about evaluation and monitoring, and it's not only about like the government agency, but also like from independent, like the main thing that Carlos and Lucia and Blanca have mentioned today about like the independent of that oversight. So that in the Vietnam case, that really also come from the civil society communities, like IPS or like UNDP Vietnam, or like other NGOs like CQ and CDI. Like we really together, united, work together and to bring these issues that normally are not on the top of the policy agenda, but with our evidence-based research, and then we bring these policy issues to the agenda and raise attention to that. So yeah, that's two points.
No, thank you very much, Lynn. Thank you for your insights. And Lucia, so what's your main takeaway to share with the audience about how we move forward on this?
Coming back to the day promoting access to information, I believe that this is a democratic issue. Democracy is built on the crucial compact that citizens will have access to reliable information and can use that information to participate in government, civic and corporate decision making. So governments need to use technology to be more transparent, more accountable and inclusive, and they need to develop the institutions as they need to be fit, because we need to innovate in how we give answers to pressing issues, including, of course, delivering better services and establishing cutting-edge systems of procurement, or advancing fiscal openness, or fighting fraud and abuse. We need to really change our mindset here and understand that the data is not owned by the government; it's the citizens. And we need to be more open about this. We need to have a less political approach to it and more society one. understanding the importance of information and data on the trust in democracy. Thank you.
No, thank you, Lucia. That's an important point about thinking these issues around democracy in the digital age as well. And Blanca, to you, what takeaway and or recommendation you would like to share with the audience about how you make both rights work?
Muchas gracias. Pues sí, mira,
Well,
creo
thank you very much. And yes, I think that it is very important the fact that today, just as yesterday we were mentioning, we value the relevance of the society, like the meaning of this personal data protection in society, because this is linked to their intimate space. And in that sense, we already were talking about this. If we achieve the openness of information, taking into consideration the minimum standard for privacy and confidentiality, well, it would be possible as well to get the information, make the information public without any for people. That is to say, and we are thinking about what's done in Mexico in a successful way, talking about the public resolution, but that have this version that will allow from the very beginning that this availability of those public versions of information through the different exercises will allow to avoid to publish confidential information. And there are a lot of examples on this and that we have here in Mexico, just as you were mentioning. We have a close relationship with the states, with dialogue, updating, and training, because we think that this is a great system where we have to be all together with the knowledge of the authorities, of the bodies that will guarantee the access to data protection. And that's why we boost all of these programs that have these capabilities to generate the public versions of judicial sentences. And this will make more efficient and optimal the process of its making, so we can achieve with the requirements by law. And I think that working in a coordinated and close way, always with a permanent data, so we can establish the limits that the same authorities must know in the data collection, what they do in the databases that are being created, with the security measures that have to be adopted in such a way that we can face the digital era, the needs that all of the new technology, and looking forward for this conciliation and balance of the access rights and data protection. So these are great challenges that we have as an institution that fights for these both two rights. And this brings an effort to think in an immediate way the positions where we have to be resolving with openness, yes, with more openness, but also the protection of personal data and also their responsible and committed use for the society to be conscious about the use and the management and openness of their personal data, and also the authorities in that minimum protection level that they must have in the use of the databases that are being built. Yes, thank you very much, Blanca.
Close to this fantastic panel, and we will move to the discussion. I just see somebody in Tashkent, but we will need to close this panel at this time. Thanking the panelists and the interventions. I think three main points that I would underscore is related to the tensions, or let's say the complementarities, but also some of the tensions between these two sets of rights, but also the discussion we have had about how the digital acceleration is transforming how these rights are playing out and can be enforced. And I think there's also the issues around that was also raised in the chat, and I invite some of the people to look at the chat in terms of also the other side of the coin of the digitalization, in terms of also the risk of excluding populations to accessing those rights, especially online, and the importance of the digital divide in terms of mitigating some of the risk of not people having access to those rights. So again, I want to close this panel here on time after this long discussion. Sorry, I see a colleague in Tashkent, but I don't know if you have a question. Maybe we can take it, but very short, because we are already out of time. But
thank you very much.
Let's go to Tashan. Yeah, go ahead. And
Thank
maybe
you
you
very
can
much.
introduce yourself.
It will take less than 1 minute.
Okay.
On behalf of UNESCO, I just wanted to thank you, OECD, for joining this this celebration and for having this wonderful panel. We are really delighted to see our cooperation here. Thank you again, and on behalf of UNESCO and on behalf of our Assistant Director General Tawfiq Jalasi. Back to you. Thanks.
Yeah, no. So you Marius, aren't you?
Yes, that's correct.
Yeah, so it's a pleasure. I'm Carlos. But also to reciprocate and to thank UNESCO for inviting us in this space, and also for us to have this occasion to celebrate together the International Days of Access to Information, and really reinforce and reiterate the importance that these issues and these challenges have for the OECD and its member states, especially in the digital age that we're going through. So again, also Marius and UNESCO also thanking you for organizing this event together. Again, thanking the panelists and thanking the many people who were listening to this fascinating conversation, both on site in Tashkent, but also online all over the world, really. So with this, thank you, and have a nice day, morning or evening, depending where you are. Thank you.